Hi, everyone. Welcome to another episode of the SCV Law and Life podcast. I'm your host, Mason Rashtian. Today, I'm joined by Donald R. McGarrah, a highly accomplished trial attorney with decades of experience handling some of the most complex and high-stakes litigation in the country. Don is currently a partner at McGarrah, Garcia, and Leet, where he serves as lead trial counsel on catastrophic personal injury cases, medical malpractice, product liability, and major commercial disputes. Over the course of his career, he has led litigation efforts across the United States, managing cases in dozens of jurisdictions and advising major manufacturers and organizations on risk, compliance, and trial strategy. He's also been deeply involved in training the next generation of trial lawyers and has served in leadership roles both within his firms and in the broader legal community. Don, it's a pleasure to have you on this show.
Thank you, Mason. I appreciate it. Appreciate your kind words.
Of course, it's all true. So take a couple of minutes, please, and tell us about your background and how you got started in this business.
Okay. Well, my father wanted to be a lawyer, and he was an admiral in the Navy. And so maybe that's one of the reasons why I ended up in this business. But I was in college studying to go into communications. I wanted to go into radio and television broadcasting. And then I looked at some of the entry-level jobs and saw that they were not very lucrative and decided to take the LSAT to see if I could do okay and enter. The idea was to get a law degree and an MBA and then enter at a higher level. I scored very, very high on the LSAT, which was a nice surprise. And so I did go to law school. I ended up in St. Louis at St. Louis University, which is a very, very strong school. It doesn't get as much accolades as WashU, but it's a very good school with very good clinical programs. But a good friend of mine was a student there, and he introduced me to a small trial firm. And so I needed to work, and I started to work part-time. And so that's how I started getting involved in trial work. And when I got out, one of the things that I talked to some people about is, if you have any interest in trial work, it's not a situation where if you go into corporate law 10 years later, you're going to come back out and start working as a trial lawyer. If you're interested in it, get out, see if you really enjoy it. And then if you don't, you can move into another area. If you do, you're setting the foundation for going forward, which is exactly what I did. Then I had an opportunity to come up here to Chicago to work for one of the top trial lawyers, not only, well, in the United States, a man named Phil Corboy, and I did. And I came up here and I worked for him for about 2 years. I joke around telling people that I'm a graduate of the University of Corboy because there's a lot of very, very good trial lawyers here in town who went through that firm, and you were basically on call 24/7, and that's okay. I mean, and it's gone from there. I've been associated with several very good firms here in Chicago. I've had very good training in the sense that, and I'm not talking about boastful, I'm just saying that I've been very fortunate, very blessed to have some great mentors and great training. Phil Corboy, Max Wildman, Jim Dorr, people like that who are very, very good people, very, very good trial lawyers. Mr. Corboy and Max or Phil and Max are no longer here, but they were both extraordinarily accomplished and great mentors. And so I that's kind of where I am. And in terms of the Wildman firm where I worked with Jim Dorr and Max, the firm became probably we represented more firearms manufacturers than any law firm in the world. And we handled all of their cases nationwide. Jim Dorr was the one who spearheaded that, and then I became part of the national team. And one of the key team members we had 7 or 8 members at one time, but Jim was in charge, and I was kind of like number 2. And so that's how I ended up trying cases on a national basis, and that's how I started. And then I started handling med mal cases on a national basis, and primarily for plaintiffs. So I've handled med mal cases for plaintiffs in 14 states, and I've handled product liability cases in 38 different states, and some commercial stuff as well. So one of the advantages I believe that I have is that I've worked with very, very good lawyers on both sides of the street, both on the defense bar and the plaintiff's bar. So I can look at cases with that kind of perspective. Now, there's a lot of great defense lawyers and a lot of great plaintiff's lawyers that don't work in both arenas, and they're very good at what they do, but that's just another nice perspective to have, because and in addition to that, on the defense side, a lot of times, a lot of lawyers are working with insurers, and particularly in the personal injury arena. In the product liability stuff that we did, we were dealing with the board of directors and the C-suite executives, because a lot of those companies had what's called an SIR, which is a self-insured retention. A lot of them had a larger SIR so that they can control litigation, which under the circumstances was a very smart thing to do, because they were facing recurrent litigation. So it was important, and that's why a lot of times, and that's not atypical when you find people in the pharmaceutical arena, that you'll have regional counsel or national counsel, because the issues are the same. They're recurrent. And so what you want to do is to put together a team of people who are very familiar with the issues, a team of experts, a team of consultants, a team of investigators, if you will, that saves the client a significant amount of time and money. I can tell you, whether it's firearms or some of the other product manufacturers that I used to represent with my partners, it was a very cost-effective thing to do for the client, because when we identified bad cases up front, and the vast majority of these companies wanted to identify, as all companies do, the nature and extent of the case and whether or not they have exposure. And if they do have exposure, let's say there was a manufacturing defect, they wanted us to get all of the information on the injured party as soon as possible, and set up an early settlement conference or mediation. And in most of the cases, we were able to do that, and we were able to resolve the vast majority of those cases. That saved the only entity who in theory might have gotten hurt by that was the law firm, because then you didn't get 2 to 3 years of billing. And having said that, that started off with this one company we represented, and everyone in the industry then started coming to us. So, I mean, it was, we were doing what was in the best interest of the client, which is what, I always try to do. Everyone who mentored me try to do. That's what we all try to do as lawyers here. And so, I say that about the law firm losing the fees kind of tongue in cheek, because if you do the right thing for the client, it will always inure to your benefit as a professional. And that's exactly what happened. So I don't know if that's what you're looking for, but that's kind of where I am. I've handled a ton of product liability cases with a lot of very complex issues, including issues involving recalls and retrofits. I've handled a ton of med mal cases, including the most catastrophic cases, which are very, very sad. These are cases involving, the birth injury cases, where these little babies typically are diagnosed with what's called HIE, which is hypoxic ischemic encephalopathy, and they're disabled for life. So in those cases are as a plaintiff, you have to be very, very careful with those cases, because they involve generally 5 to 7 experts. You're going to be spending, even if you do so in a very, very time-effective fashion, it's going to take a year to 2 at a minimum, and you're spending several $100,000 to properly prepare those cases. And the defense bar in those kinds of cases, generally what I found around the United States is you're dealing with some of the top trial lawyers, and they're very, very good, and they know exactly what they're doing. And but the point I guess I'm trying to make is being involved with those kinds of cases gives you a high level of experience and understanding and knowledge of complex litigation. So.
Right. Yeah. So, I mean, being on both sides is going to help. I mean, that's how I started mine. I cut my teeth as a insurance defense attorney, working for panel counsel for the first 9 years. So I know exactly what you mean. And even nowadays, I'm more objective when it comes to my clients and when we negotiate. I give them
Sure.
the good and the bad because I see both sides of it. So
Right.
it always helps to be on the both sides. Yeah.
I agree.
Yeah.
I mean, in the insurance industry, and I'm sure you were asked the same thing, you would be asked, how many times out of 10 are you going to win this case? What's the, settlement value? What's the verdict value? Um, and what are witness capabilities? This business, in terms of litigation, and this actually applies to any kind of litigation, in my view, and including criminal litigation, this is all about risk. You need to understand the concept of risk. With respect to personal injury incidents, the fundamental question is what happened and why. And then once you understand that, you're in a position to handle the case on behalf of your client, whether it's a plaintiff or a defendant, in a very effective fashion. And one of my old experts, a gentleman who sadly passed away about 6 years ago, although he had a great life, he lived to be 94. He said, at some point, Don, you get to the true facts. And he says, once you're there, you're able to manage. And what he basically means by that is, once you figure out exactly what happened and why in any setting, then you'll know as a plaintiff whether or not you have a basis to pursue a case, and whether or not you're going to be you have a chance at being successful, whether or not, as a defendant, you have exposure and the nature and extent of that exposure, and things like that. He was a very, very wise guy. And, that kind of restates the obvious. That's the business that we're in. And so if you understand that, quite frankly, when I get into a case, particularly a bigger case, um, I prefer to have a good lawyer on the other side, because they'll evaluate the case
Right.
the same way our firm evaluates it. And if it's a case of exposure for the defendant, you'll be able to resolve that at a relatively early stage
Yeah.
by way of mediation or some other vehicle like that. Or you'll find out that there's a significant difference of opinion on value, and then you ratchet it up, get ready, and go try it.
I 100% agree with you. When I have cases, I would much rather have the partner of the firm on the other side than somebody who's been at law school for a couple of years, because you're
Right.
right. They don't know the value of the case. They don't know what the pitfalls are. Yeah, they're just big
Right.
difference.
Well,
Yeah.
I'll give you a very specific example, and I'm certainly not going to identify the individuals involved in this, but I was asked to lead up a team, I think it's about 7 or 8 years ago, of defending cases, and I won't identify the product either, but it was a Japanese manufacturer, a very responsible company, but they had an issue with one of the products, and it was recurrent litigation. And the insurer, who handled both the primary and the excess, they sent one of their so-called top VPs to participate in this, and we would have quarterly meetings where all of the lawyers all around the country, and I headed up the team, and we had people in different cities would be on the call, and we would talk about issues. We would talk about upcoming trials. We would talk about experts, things like that. And the individual who had been assigned from the insurance company had been in that business for a long time, but had very, very little product liability experience. I don't know how that happened. I wasn't an employee of the company, but it was not the right person for that job. And so we would have these meetings, and there would be some discussions that would be totally nonsensical and kind of a waste of time. I'm not saying the person was acting in good faith. They were, but they just didn't have the background and expertise and experience in that arena. So your point is very, very well taken.
Yeah.
You cut to the chase sooner rather than later.
Yeah, even attorneys who've been attorney for a long time but never practiced in what we do are not litigators. A lot of times when they show up in our arena, they don't understand the pitfalls and the issues, and they just don't. It's not the same thing. Um, so what do you do now with the younger attorneys? First, let me back up a little bit. Do you guys have your associates work in the office, or are they remote, or is it a combination?
It's a combination. Most of the people here in Chicago come in not every day, but they come in, I would say, 3 to 4 days a week. I think that the remote business doesn't bother me as long as the work gets done. The problem with that is, I know that I'm a little older than many lawyers, but it was something that I thought was absolutely essential was the in-person mentoring that you get, when you work with people together. Some of that's lost in translation when you're interacting with people on Zoom all the time. And Zoom has a function, and that's fine, and it's great, and it saves a lot of money in certain limited circumstances. But it is, I think, essential to have in-person mentoring from time to time, because it's also the way in which the younger lawyers understand how to communicate and interact with people, particularly in difficult circumstances. And there is a cultural change. There's been a significant cultural change, and I'm not suggesting the culture's now worse, because a lot of the younger lawyers do not want to or are not willing to work the hours that we worked when we were younger. And when I say we, I'm talking about you and I and people of our, but this is what Phil used to say is this is a crisis-oriented business. And he's right about that. And you don't have to be on 24/7, but if you're going to litigate, and I shouldn't say litigate, try cases at a high level, you've got to be prepared to rock and roll on a 24/7 basis from time to time, and so I don't see that as much now. And as I've indicated, it's a cultural change. I was with another one of the firms I was with here in town was a small firm. We had 4 lawyers. And every time we had a trial is all hands on deck. And our youngest lawyer, who eventually became a partner, he's a great guy. First trial we had, I saw him walking out the door at 5:15. I said, "Where are you going, David?" "Well, I've got to go take care of daycare and this and that and the other." And I said, "Well, we're in the middle of a very large trial here. What you need to think about doing is modifying that for the next 2 weeks." And he said, "Oh, okay." Well, he did do that. And but whereas the old days, my friend Phil would call me up at 6 o'clock on a Sunday morning. He'd literally say, help me out, Don. What's going on with this? Blah, blah, blah. And he did that in part to let us know that he was still in charge, but he also, knew and understood from time to time you had to be on call 24/7.
I'll give you an example. When I did defense work, we used to defend HVAC installers a lot of times, right?
Okay.
And we had one case where our client, who was a pretty big client at the time, installed an HVAC system in Aaron Spelling's beach house, right?
Okay.
Remember Aaron Spelling?
Sure, absolutely.
So one year, one weekend, Candy Spelling goes to the beach house, doesn't know how to use the HVAC system. So she fires everybody, have somebody put a brand new system in there, and sues everybody. Okay. So that case ended up going to trial. And I still remember to this day, when it was the middle of the trial, my wife was giving birth, and the boss who I worked on the case would call me because he had questions going on. Until this day, my wife goes, "I remember Ted calling you and was in labor." So yeah, as litigators, we have to be on almost all the time. We're a different animal than the rest of the attorneys.
I agree.
Yeah.
I agree. So I handle a case out in your neck of the woods. I've handled actually a lot of cases out there, but one was a very sad case, a catastrophic case. I defended it. A young man who was in an acting school there, who literally brought a real gun in to try to replicate a scene from Lethal Weapon, where Mel Gibson was contemplating suicide. And this young man brought in a real firearm. It was loaded, it was cocked, the safety was off, so that all he had to do was to pull the trigger for it to go off. He didn't understand that, or at least that's what we concluded, because when he went into this, and this was in a very famous acting studio in Los Angeles. We had an audio tape of what happened, and the acting coach was saying they were trying to. There's a method, I think it's called method acting, where you go in and you really try to be the person. And so he had said that he had put together what's called, and these are his words, not mine, a safe rote method of handling this firearm. And when he got on the stage and they were yelling at him, do it, effing do it, blah, 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 he said he got nervous and he inadvertently or mistakenly hit the safety button. So now you've got a firearm, as I said just a second ago, it's loaded, it's cocked, the safety's off. The scene from Lethal Weapon was Mel Gibson was using a firearm called a double action semi-automatic pistol. There's more play in the trigger than if you have a single action. And this gun that this young man brought in was single action. So he literally put it in his mouth to replicate the scene, and he pulled the trigger.
Oh boy.
And it blew out part of his cervical spine. A very, very sad case. It went up to the California Supreme Court, and because we got summary judgment, and it was affirmed. The acting studio, I will tell you, should not have gotten out of the case, and they did. I thought the judge was absolutely wrong about that. They didn't have any safety policies in place. This young man never should have been permitted to walk in there with a loaded firearm. I don't know if you remember years ago, there was a series called Centennial. I'm showing my age because I think it was in the 90s. But they had a very tragic circumstance on the set with an actor who picked up a blank gun. And he said to someone, don't worry about it, it's not loaded. He put it up to his temple, pulled the trigger, and it went off. Well, a blank gun is not designed to shoot bullets, but it emits gases. So this gas permeated the actor's temple, and sadly he died. And from that point forward, I think it was the Screen Actors Guild, and it was a very responsible thing to do. They started requiring certified firearms experts being on the scene. There were very specific rules. And these are, if you go into the military or the police, these are the kind of rules that they use all the time. And they're designed to prevent accidents and injuries. So that was an interesting case. And the other thing that was interesting about that is that the players, everyone who was involved, was a member of the Church of Scientology. So they were overseeing everything that was going on as well. I should sit down and write a book about that.
You should.
Experience. So,
yeah, it's funny. I've been saying this for years. One day I'm going to write a book that says all the cases that we haven't taken.
Right.
Because once people find out all the shit that we get calls for, it's like,
wow, that's a great idea. I mean, it really is.
So the stuff you're telling me is very similar to what happened to Alec Baldwin, right?
Yeah.
In a way?
Yeah, absolutely. I mean, I didn't see any of the testimony in that case, but when I heard about it and I heard about some of the stories, then someone had not done their job, because that was a real firearm with real ammunition. And if you're going to use that on a set so that you can get realistic sound, you need to have qualified firearms instructors there. I mean, there's some very, very basic safety things, and that never should have happened under any set of circumstances. But I don't, the devil, as you know, I use this phrase all the time, devil's in the details. I haven't seen the investigative report. I haven't seen the testimony, so I'd like to see that. But, there was a reference to an armorer. That's the person who's responsible for maintaining whatever firearms you have and maintaining them in a functional fashion and from a safety standpoint. So the fact that they had a loaded firearm, that to me doesn't make sense. If in fact you're going to use a loaded firearm under those circumstances, you should have what's called a cutaway, where you have shots of the firearm, but then the firearm would be pointed downrange at a very safe location. And there's very basic rules, and one of them
Yeah,
is
it just,
you
to
never
me,
point
it's y-
a gun at anything you don't intend to shoot. But go ahead.
yeah. I was gonna say there's no reason to even have a law firearm. It just doesn't make any sense. Just
I agree.
basic. Yeah.
And in today's day and age, if you want to simulate something, you can use, as I indicated a few minutes ago, blank ammunition, but even that has dangers associated with it. And if people don't understand that, the actors need to be given very specific training. And even then, as you go through each scene, the gentleman I spoke to you about a little while ago, one of my, the gentleman who said sometime you get to the true facts. His name is Bob Frazier. He was with the FBI for over 40 years. And when we worked with him with a firearm, you handed him a firearm, he would check it in a very safe fashion to make sure it was unloaded. And if someone else handled it and it handed it back to him, he wouldn't assume, he would check it
Check it
again. Those are very basic, common sense things to do.
Yeah.
So, and you avoid, these terrible accidental discharges.
Yeah.
When you do that.
So I noticed that you also gave me a sheet about the medical malpractice verdicts that you've had over the years. In California, you have micro, which puts a cap on general damages, which are non-economic damages. Do they have such things in other states?
They do, but not every state. Illinois doesn't have that. Indiana does. Indiana's got a hard cap, 1.25 million, which I think is absolutely unconstitutional. It does not reflect anything with respect to the nature and extent of some of these injuries, including or particularly catastrophic injuries. And
Yeah,
so,
in California, it was 250,000 for 50 years until it finally went up.
yeah, no, that doesn't. That is a result of some very, very powerful, well-funded lobbying group getting that done, because it certainly doesn't reflect reality.
Yeah, I totally agree. I mean, some of these folks, when they're really injured, it's a lifetime issue. You're right.
Absolutely.
Yeah.
And they, that kind of money with a catastrophically injured individual really does nothing to take care of them.
So I know you've had cases in different states. Do you have a favorite state that you would say that you practiced in?
I would say I love going to South Carolina, Georgia, or Florida, or Texas in January, in February, in March. But no, I mean, the favorite states, I've had some absolutely interesting experiences, fascinating experiences in Texas. I've tried a lot of cases down there. I had one case in which a local judge put my opposing expert in jail, and that was a lot of fun. And then the people in Oklahoma are hospitable. But, I got to tell you, every place that I've gone, for the most part, you find very, very good people. You find some people are not so good, and people are kind of looking for the same thing, to have a decent life. And so I tried a case once in Ohio. The judge was a character, and at the end of the case, he came over. We had the goods on our opposing expert, and our opponent unfortunately didn't understand that. And actually, it wasn't the judge. One of the jurors came over to us after the case was over, knock on wood, and said, if I was standing in a rainstorm and it was pouring rain and this expert said it was raining, I wouldn't have believed it, because the guy had so much baggage. But it was fascinating that the people were willing to reach out on something like that. Now, that's the exception to the rule. I've had a lot of great experiences in California. Although the traffic out there is always a lot of fun, particularly in Southern California. And but the weather out there is great, so but that's it.
Yeah, we get the weather, but we also get the traffic. Yeah, I know how it is.
Well, I came into LAX one night on a Friday night, and I knew this was going to be a challenge, and I had a meeting up in Calabasas. From the time I got in my rental car, which was about 5:30, I got off the highway up in Calabasas around 7:30. I mean,
Oh,
Now,
that's
that's the
actually,
worst time of the world. It's Friday evening in rush hour traffic.
yeah, that's actually good timing. You talk about the
Oh, right.
405 and the 101. I would have
Yes.
expected you to get there at 9.
Oh, okay.
So be glad.
No, I thought that was interesting.
So do you find laws pretty much the same around the country? I mean, most of them are common law except for Louisiana.
It is.
Are they,
Yeah,
yeah.
I think, in terms of the business that we're in terms of personal injury, the algorithm is the same. It's duty, breach, causation, damages. And that sounds like an oversimplification, but that's essentially, what we're dealing with. And as plaintiff, as you know, we've got the burden of proving all of those elements. It's interesting that the language in the jury instructions is not the same, but the points are essentially the same. And then I have handled cases down in Louisiana in terms of the Napoleonic Code, which is it's a little different. It's like being in a little different nation down there. The people are the same. I mean, the people are great, and I love the Cajun accents down there. But the essence of the common law in most states is the same. The things that you run into that have differences would be like in the med mal arena, where the states who have put in place the so-called tort reform, you've got to be very cognizant of the limitations there. And I mentioned Indiana a few minutes ago, and I'll mention them again. If you have a med mal case there, you have to run it through a system where it's reviewed by a panel. And that's a very conservative jurisdiction, and they have, as I said, these absolute caps. In the that system, some people on the defense may argue with me about this, but I think it certainly favors the medical arena. And so we have offices in Indiana. We handled med mal cases in Indiana, but we may not handle the same type of cases there that we would, for instance, in Illinois, in some limited circumstances, just because of the process and the caps. It just becomes, it is not a cost-effective thing to do, and we have to be very cognizant of that in terms of the other cases that we're handling as well.
Yeah. I know we've been talking. I forgot to ask you. People want to get a hold of you. They need your services. How do they get a hold of you?
Well, I mean, they can email me. It's a very simple email, Donald at McCready Law, McCready, Donald at McCreadyLaw.com. And that's the best way to go about doing it. I also give people my cell phone because that's the best way to get a hold of me. I tell people to just text me. I can be in the middle of a trial and I get a text, and then during a break, I'll get back to them. But that's 630-817-1503, 630-817-1503. That or the email is the most effective way of getting it done.
Okay. So as litigators, it's a hard life. You and I both know.
Mhm.
You're fighting with somebody all the time. So how do you keep balanced?
I think you need to have a healthy sense of humor. I think you need to have an irreverent sense of humor. I think you need to understand how to turn down the volume. We had a attorneys meeting here about 3 weeks ago, and I said this to a lot of the younger lawyers. Number one, I said you need to embrace the chaos. In other words, there's a lot of things you run into in this arena, as you know, that are not, I don't want to say they're not anticipated, but you know that you're going to run into issues from time to time. But if you take the attitude, wait a minute, this is a problem, I've got to react to it, and then you get stressed out, as opposed to saying, okay, this is part of the process. Expect the unexpected. And that's true not only in our business, but in a trial. And so if you have the attitude that you're going to run into certain circumstances that are, quote, unexpected, and then you develop the attitude, okay, that I'm going to quietly, meticulously, and purposely look at adjust, adapt, and overcome, you're going to be in a much better position to handle the stressors in this business. But there's also I work out every other day. It doesn't matter. That helps me turn down the volume. And I also engage in a process called the Jacobson progressive relaxation technique. I don't do it as much as I want to, but that's a situation where you flex and you contract and relax your muscles, and you do it from head to toe. And sorry about that.
Okay.
And you do that purposely, and that's a way to relax your physiology. And if you do that, hold on one second.
Sure.
I'm in the middle of a conference call, a podcast. If you can hold off, please. Thanks. Bye-bye. If you do that, you're able to turn down the volume. It literally allows you to relax. And I'm not talking about relaxing like out on a beach, but it slows everything down. And that's another thing I tell the young lawyers, slow things down if you can. Be purposeful, because if you're not careful about it in this business, as you turn out to be, you're reacting every day, all day to things, as opposed to being proactive. So
Yeah, that's a major thing. When I was a young attorney, you're always reacting all the time, always trying to get those billables, and worked on the weekends.
Sure.
That's the good thing about having my own office. I don't have to worry about that anymore.
What do you do to turn down the volume? I would ask you.
Unfortunately, I don't do enough.
Mm-hmm.
I should do some of the stuff you say. I should meditate, but I don't. Mm-hmm. I should go to the gym, and I have a gym membership, and I don't. So it's I don't know what this. Once in a while, I'll take an extra day off. That'll help, but it's just not. It's consistent. So.
Well, I mean, some of the experiences that we have in this business are Monty Python experiences. They're kind of laugh out loud. And I think that, most of the people that I interact with who are in this business from time to time, hopefully develop a good sense of humor, and can manage things like that. But I think it is important to turn down the volume when you can, and get away from it when you can. So
yeah. So when I go on vacation or on the weekend, I pretty much, especially on vacation, unless it's an emergency, don't contact me. My assistant, she'll take care of everything else, because I need that break. That's why I can't work from home. I have to have a break between my home life and my office. When I'm in the office, it's work. When I get home, I need that break.
Yeah. Well, I understand exactly what you're saying.
Yeah.
So
one last question. As you sit here today, based on your current knowledge, if you met your 10-year-old self, Don, what advice would you give him?
Well, I mean, I would say find something you're passionate about, and find a calling, not a job, not an occupation, not a profession. Find your calling. Find something you're really passionate about and get involved, because that then is not a job. That's something that you will enjoy and embrace, forever and ever. And so that is something that has been said to me over the years. I've read about it, and I think it's some of the best advice I've ever heard and seen. So
that's good advice. All right, please tell everyone again how they can get a hold of you.
McCready Law, if you Google that, you'll find our website, our firm's website, McCready, McCready Law. And then my email is very easy. It's donald@mccreadylaw.com. And then I've got a cell phone, and feel free to text or call me, 630-817-1503.
Folks, if you have a major catastrophic injury, or if you just have some questions and need great advice, there's no reason not to at least seek an advice from Don, because he knows this stuff. Trust me. I've been in this for a long time, and I can tell when I talk to other attorneys who knows their stuff and who doesn't. I can tell you Don knows his stuff. So
that's very kind of you. Thank you.
But thank you so much for being a guest on the podcast. As I said earlier before to you, you're the first personal injury attorney I've had on my podcast.
Okay.
I've had, other attorneys, but none of them the PI attorney, because I only take the best from the best.
Okay.
And
Well,
for
thank
everybody
you.
who's listening and watching, please, if you like us and subscribe to our channel. Thank you so much.
Thanks again.